Hi, and welcome to another in the American Museum of Tort Law's continuing video series of interesting talks with interesting people on a variety of law-related topics. I'm your host, Rick Newman, Executive Director of the American Museum of Tort Law. Our guest today is Deepak Gupta, who is the founder of the well-known national litigation firm Gupta Wessler. Deepak just argued and won an important case before the United States Supreme Court, which is an important victory for consumers. Deepak, welcome. It's good to see you again.
Good to see you too. Thanks for having me.
So we're here to talk about these two cases, Ford Motor Company versus Montana 8th Judicial District Court and Ford Motor Company versus Bandemer. Am I pronouncing that right?
Yeah, that's right.
So first of all, what were these cases about? Let's set the stage and then we'll talk about what happened.
So these are sort of, garden variety cases. They're car accidents that lead to product liability claims. And these kinds of cases happen all over the country all the time. And they, generally don't reach the US Supreme Court. They're heard in state court. Product liability law is decided under state law. And so, in the ordinary course, these cases would have been brought in the state courts in the places where the accidents occurred. You had one case, tragic case in Montana, where a young woman was driving a Ford Explorer. And the Ford Explorer has a well-known defect where it rolls over, and it rolled over into a ditch and actually killed her. And there was another case in Minnesota, where a man was in the passenger seat driving with a friend to an ice fishing trip. And the car hit a county snowplow. This is in the winter on a rural road in Minnesota. And also went into a ditch. And he didn't die, but he suffered really serious brain injuries. And so both of these cases, everything about the case was localized. In the Minnesota case, you had an accident with Minnesotans and other Minnesotans on a Minnesota road, and these cars were purchased by the people who owned them in that state. And so you would have thought that those cases would be heard in Minnesota and Montana courts, no questions asked. And I think, maybe 30, 40, 50 years ago, there wouldn't have been any questions asked about where the cases would be heard. But because the US Supreme Court has narrowed jurisdiction, has narrowed the concept of personal jurisdiction so much, these cases raised the question of whether or not Ford, the company that sold these cars, couldn't be sued in Minnesota or Montana because the particular cars in question were manufactured, designed, and originally sold to the first purchaser in different states. And so Ford...
If I understand this then, Ford makes these cars, sells them in, we'll say, Nebraska, just
Sure.
Be somewhere in the middle. They end up getting resold into Montana and Minnesota. The
Right.
accidents happen there. And so the victims sue Ford.
Yeah,
in
exactly.
Montana and Minnesota, respectively.
Exactly.
And Ford says, you don't have jurisdiction over us?
Yeah, exactly. Even though everything about this accident took place in Minnesota or Montana, all the people, all the evidence, everything is in those places. Ford said, well, if you look at it from our perspective, we didn't actually do anything in Minnesota or Montana with respect to this particular vehicle. We made it somewhere else, we designed it somewhere else, and we sold it to the customer who bought it from us somewhere else. So, if jurisdiction requires that we did something that caused your claims, tough luck. You've got to sue us somewhere else. That was their argument.
And just by brief digression, jurisdiction, as I understand it, is the authority of a given court to haul the parties to a lawsuit into its jurisdiction, into its authority, and there decide the case.
Exactly.
So Ford is saying you've got to be a detective, figure out where this actual vehicle was manufactured, and track it down to Nebraska or North Carolina, wherever it happened to have been, and sue there.
Exactly. And all of this, Ford says, is because the due process clause of the Constitution mandates it. So as you say, jurisdiction is the power of a court to hear the case. But the US Supreme Court has interpreted the due process clause of the 14th Amendment to the Constitution to place limits on jurisdiction. And the idea was originally animated in, fairness to the defendant. The idea is it's unfair to make somebody answer for a lawsuit in some distant place. And if you are a small merchant who makes something in Maine and you get sued in New Mexico, and you've never been to New Mexico and you haven't done any business with New Mexico, I mean, perhaps that makes sense. But this kind of due process argument doesn't make very much sense when you're dealing with a large multinational corporation like Ford that sells its products everywhere in the United States. But that was the theory anyway. So that's the legal issue that comes to the US Supreme Court.
And how did it come to the Supreme Court? Again, the Supreme Court is asked to hear cases all the time and exercises its own discretion as to which cases it will take or not take. So why did these two hit the radar hard enough to get to be Supreme Court cases?
Yeah, I mean, I have to say, when I saw these cert petitions, and there were two cert petitions filed on the same day by Ford, one from the case in Minnesota and one from Montana, I did think that it was quite likely that the court would take the cases. And the reason is that, first, the court has been very interested in this jurisdictional landscape, and they have been narrowing jurisdiction steadily for the past several decades. And there was a recent case called Bristol-Myers Squibb where the court had granted cert to decide this question of, whether or not there's a causal test, whether or not you have to show that the defendant did something that caused the claim in the jurisdiction. And in that case, Bristol-Myers Squibb, the court failed to decide that question. So that's often a really good indication that the Supreme Court is going to take a case when it's already granted to decide a particular question and has failed to reach the question. And so, we thought there was a good chance that the court would take the case, and there were lower courts that were buying Ford's argument, believe it or not. And so, Ford made a somewhat persuasive case that the court needed to take the case to clarify the law.
Okay. And now in the COVID pandemic era, how did the actual Supreme Court proceeding, you're the one who argued it, you're the one who won it, how did that work?
Yeah, I mean, it's a crazy thing. Arguing a case before the US Supreme Court, even in normal times, is a daunting task, right? You are going to be talking to 9 different people. They're going to be peppering you with questions. You don't have time to think. And so what I do is do a lot of moot courts, get the hardest questions so that I know what those questions are. I've thought up my answers, and I can be there in the moment and have a conversation with the justices. But during the pandemic, the court decided it was going to do arguments by telephone. Some of the lower appellate courts are doing arguments by Zoom, by video, talking the way you and I are right now. And I can see your face, I can see your body language, I can see if you are skeptical of something I'm saying, I'm going to see that in your face. But because the Supreme Court decided they don't want cameras in their proceedings, they don't want to set a precedent, they did not have video. And so it means you're having this conversation with all of these people, and you don't know precisely what they're thinking. And, if you have 8 or 9 people and they're all going to be jumping in and asking questions, that's not feasible on a phone format. And so they decided to break up the time into small increments and give each of the justices questions in order of seniority, which meant Justice Thomas was asking questions, which he never does. So the whole thing was thrown off. And it's a very strange format where you had to speak almost one-on-one with each justice. But at the same time, you're always trying to really persuade the whole court, and you can't see them, and you can't read the room. Reading the room is an important part of giving an oral argument in that court. So it was challenging. And what I did was practice arguing using that format. So practiced where my colleagues were asking me questions and I couldn't see their face, and the time cut off every 2 minutes. And so it was like learning a new skill on top of all of the complexity of arguing, a challenging case like this in that court.
And so how long was actually allocated for the argument?
The same amount of time that they normally allocate, so half an hour per side, but then they broke it up. So if you had 8 justices, because Justice Barrett wasn't there at the time, you're dividing that 30 minutes up. They give you 2 minutes to speak at the beginning without interruption. The Chief Justice is giving people about a minute to wrap up, and then the rest of that time is divided up equally among the justices. So it makes for a very structured, kind of artificial conversation, and you have to make your points really, really quickly. You have to know what your soundbite answers are to the precise concern that a justice is raising, a hypothetical or a question. Chief Justice Gorsuch tried to ask me 5 or 6 questions in his allotted time because he was so interested, and it was a real challenge to answer them all with one response.
And they don't say, given this odd format, we'll give you another 30 seconds if you need it. You're still held strictly to the schedule.
Yeah, that's what they were doing, at least at that point in the pandemic. There have been some recent arguments where the chief has allowed things to go on a bit longer, which I think is sensible. But this court still has spittoons next to the bench. They're very tradition bound, and they're very slow to change. So I think they did their best to try to take their traditional format and adapt it to the COVID era with, some success and some ways in which it fell short, I think.
Did everybody have questions, or did any of the justices say, no, pass me?
No, these are not shy people. They were all very interested. They all had questions. Justice Gorsuch wanted to rethink the whole area from originalist principles from the ground up.
Hard to do in 2 minutes.
Very hard to do in 2 minutes. Yeah. And some of them had very, very precise hypotheticals about what happens in the next case. I think it's fair to say, though, that the justices seemed united in thinking that if the doctrine took them so far as to foreclose jurisdiction, even in this kind of garden variety scenario, then there was something wrong with the doctrine. Mm-hmm. And that was the pitch that I really wanted to make to them, that ultimately there has to be a dose of common sense in all of this. You could take the formal logic of the court's prior precedents and get to where Ford wanted to go. In any Supreme Court case, that's always going to be the case, that the doctrine is open enough that it can go in either direction. But it made no sense. And this was the kind of case where I just thought, if I told someone, a non-lawyer at a cocktail party, what this case was about, they would all think that our side had to prevail. Mm-hmm. And so over and over again in the oral argument, in the briefing, our job was to just stress the practical implications for ordinary people. And so I'm pleased that the case came out the way it did. Not just that we prevailed, but that Justice Kagan wrote, I think, a really fine opinion that teaches lower courts how to think about personal jurisdiction and rejects this very kind of crabbed causal logic.
All right. Before we get there, let me ask, what was, distill, if you would, Ford's argument to a sentence or two? What was their claim? How were they harmed by the exercise of jurisdiction in Minnesota or Montana?
Well, so you asked 2 questions, summarize their argument and how were they harmed. The first one is easier to answer. They have a very simple argument. It's, we didn't do anything that caused your claims, and jurisdiction requires some contacts with the forum, and the claims have to arise out of those contacts. That's their argument. It's very simple. It's very rooted in the case law, and they say, we didn't do anything there. In terms of how they were harmed, I always thought that was a pretty tough ground for them, and we beat them pretty hard about this. We beat them over and over. it was really hard for them to explain how that was in any way unfair to Ford. I think the best they could do is to say, look, we make decisions about where we make and sell things, and we have the right to, decide to sell more product in a particular state if we like the laws there and we feel comfortable facing the courts there. And we can make fine-grained decisions about how we do that. But, nobody thinks that that's how it really works in the real world.
Mm-hmm.
A company like Ford wants to sell as much product as it can in as many places as it can. So the notion that they're going to sell less cars in Montana, but not completely exit the market because they want to avoid a certain degree of lawsuits there, it's just not realistic.
Mm-hmm. And so did you get a sense following the argument as to how this was going to go, or were they holding all their cards close to the chest?
No, I think you can usually tell quite a bit based on how a Supreme Court, it's always a hazard to predict with complete confidence, but I felt pretty good that the justices that were going to be the most skeptical, justices like Justice Alito, even he didn't seem to be terribly sympathetic to Ford's ultimate conclusion. Now, I mean, Justice Alito was the justice who went the furthest in Ford's direction. He thought that the court didn't have to depart from a causal test in order for us to win. But even he wasn't there. And I just think this is one of those situations in which common sense really seemed to carry the day with the justices. So I hoped that going in, but I had to be modest in predicting what would happen, because the last time a plaintiff won one of these personal jurisdiction cases about the defendant's contacts was the 1980s.
Wow.
So the middle of the 1980s. Yeah. So
what was the decision? Two-part question. What was the decision, and what are the implications or consequences of the decision?
So in one sense, the decision was unanimous. Every single justice agreed with us that these consumers should be able to sue Ford in the place where they were injured and where they purchased these cars that Ford in fact sells in those jurisdictions. And that's great. So that's the bottom line conclusion. I think that unanimity masks some differences of approach among the justices. Justice Kagan wrote for the majority, but Justices Thomas and Gorsuch and Justice Alito didn't join her opinion. And her opinion really it followed the pitch that we made in our briefs and at oral argument. It said that look, when you're trying to figure out, once a defendant has contacts with a particular state, you're trying to figure out whether there's specific jurisdiction. You ask whether those contacts are either whether the claim arises out of the contacts or relates to the contacts. And relates to doesn't have to mean that there's a rigidly narrow, provably causal relationship. It can mean that, for example, Ford sells exactly this product in that jurisdiction, and so it knows that it is likely to face suit because of those contacts, and that it's fair for it to face suit for those contacts. So that is the rule going forward. Justice Alito said that you can stick to a causal test, and he thought that even on a causal test that was satisfied on these facts. And then Justice Gorsuch, along with Justice Thomas, went in a completely different direction. They said that we should rethink this whole area of law based on an original understanding of what the Due Process Clause meant at the time it was enacted or drafted, although he didn't really spell out precisely what that original understanding is.
Mm-hmm. All right. And so does this, I'm trying to ask this in a neutral way without having a loaded question, but it sounds like this is a decision that will actually be very helpful to injured consumers insofar as they can sue in the place where the injury occurred.
Absolutely. And I think there's a tendency to think about this as about just simply where they can sue. But in a lot of cases, if someone has to go all the way across the country, or if it's a foreign corporation, they have to go to the corporation's home country. The reality is that they're just not going to meaningfully seek justice or be able to. And so, and I think Ford knew that. I think one of the reasons Ford wanted this rule was not simply to change the location of the suit, but to dissuade people from seeking justice. So this has enormous implications for access to justice. It means that injured consumers will be able to sue product manufacturers where they live. When an accident or some terrible thing happens, they'll be able to sue anyone who might have been responsible in the place where it happened. If Ford had prevailed, lawsuits might have gotten broken up into many different jurisdictions, which would be very practically difficult, especially when you're thinking about joint and several liability in tort. And so I do think this is a really critical decision in favor of access to justice. And from a court, from a US Supreme Court that is often erecting barriers to access to justice. This is not a court known for being pro-plaintiff or being, skeptical of business, big business. And so, it's I think to a lot of people a surprising victory for the little guy.
All right, two last questions, and then we'll wrap this up. First, what is the Supreme Court procedure to let you know the outcome? In other words, how did you find out their decision?
Well, the Supreme Court does call you. They telephone you and let you know. And I think in the old days, that's probably how you found out you received a call from the Supreme Court, if you weren't actually there in the courtroom waiting for the decision. But these days, everyone knows on the internet when the court is going to issue decisions. And if you know you have a case that hasn't been decided yet, you are anxiously refreshing several internet sources. For me, it's Twitter and SCOTUS blog and the Supreme Court's own website. And so I knew within seconds that the decision had come down. And I kind of had a feeling, I don't know why, but I had a feeling the night before that the decision was going to come down that morning.
And then human interest, how did you react or celebrate? What happened then?
Well, it's the pandemic, so it's a little sad. Normally I would have been, celebrating with all my colleagues. We probably would have gone out to lunch or something like that, but we were all still in different places. So we just, talked to each other on the phone or over the internet. But my wife and I did go out to have a nice dinner. Outdoors, of course.
Yeah. Still very nice, very nice.
Yeah.
And it's an important case because it does clarify and simplify the ability of injured people or the estates of people killed by defective products to sue lex loci delicti, the law of the place of the wrong.
That's right.
And good work. Good job.
Thank you. Yeah, no, thank you so much. And it's been fun talking to you about it.
Well, thank you. This is Deepak Gupta, who has just prevailed in these important decisions protecting consumer rights. If you like this video, please subscribe because we have more like it, and hit the like button. Also, if you have a minute, go to the museum website, www.tortmuseum.org. And there we have a virtual tour, free, online, all about tort law and how it protects consumers and victims from wrongdoing. Anyway, please pay attention to this sort of stuff. The law affects us all. This is Rick Newman saying thank you. See you soon. Bye.